district court. And so let me give you an overview of what we do. In district court, there's a high number of filings. It results in congested court calendars. We use standardized forms, standardized operating procedures in order to process the work. Brevity of argument, completeness and accuracy of your forms, your timeliness of actions as required by the rules are essential for a successful district court practice. So let me share some boring statistics with you to give you a feel of what I'm talking about. In fiscal year 2017-18, there were a total cases of 11,596 cases. We started with about 4,700 cases. There were 6,800 cases added to that for a total of approximately 11,600 cases. So most of these cases end up in Wailuku District Court. We have two courtrooms. We'll be going over the calendars with you, but those two courtrooms are 3C and 3D with our able district court judges there. Civil cases happen only on Mondays. That's the only day we have available. We have 49 civil calendar days per year, 49 Mondays to do these cases, and that works out to approximately 95 cases on Judge Kobayashi's 3C calendar every Monday. That works out to about 3.47 minutes per case. Now, remember, this includes every case, average time, trials, answers, whatever you have. That's the average time. Courtroom 3D, there's an average of 9.3 TRO cases with an average of 22.5 minutes per case to resolve. On the afternoon small claims calendar, 15 average cases with 8.5 minutes available to resolve those cases. Those numbers sound ridiculous, but those are what the calculations are and what the statistics are. So let me talk about some jurisdictional issues. I told you we're a court of limited jurisdiction. It turns out that the district court is overwhelmed because the specific grants of jurisdiction are typical problems. So HRS 604-5 provides civil jurisdiction for cases where the debt, the amount of damages or value of the claimed property does not exceed $40,000. That's our cap. We have exclusive jurisdiction over summary possession cases, HRS 666-6, ejectment proceedings, HRS 604-6, and civil cases where the relief sought is under $10,000, HRS 604-5A. We also have specific grants under specific statutes for tax collection, restraint of trade, and for replevin, leased or rented personal property. Of those cases, the district court runs a small claims division which has exclusive jurisdiction for claims for money under $5,000, claims for a sumsit under $5,000, and claims for return of security deposit in landlord-tenant cases. We don't do any jury trials, and we have no jurisdiction over important things, real estate actions, actions involving title to real estate, action for libel, slander, defamation, malicious prosecution, false imprisonment, breach of promise of marriage or seduction. We have no power to appoint referees. We have no equity jurisdiction. We have no power to grant this declaratory relief and no power to grant injunctive relief. So all the important stuff, things that are very common, we don't do. And so there are certain exceptions. We have an exception for the power to grant injunctions against civil harassment under 604-10.5. We have the power of specific performance where the amount does not exceed $20,000, 604-5A. And we have original jurisdiction to issue injunctive relief under Chapter 521, your landlord-tenant cases. So the judge can make orders, for example, to repair, to replace, to refund, to reform, to rescind the contract. Right? Very narrow narrowly specified areas where we have injunctive relief power. So, with all of that said, how do you start a case? You do the client intake, you do a good intake. Don't make things up as you go along. You get the evidence up front, you get the proof up front. You should have a very good idea of what the problem is, what the relief is that you're wanting, because if you come into court and the judge asks you, what do you want? You're not going down the right path, you're not doing well. So, I would suggest you talk to your client, lay out the alternatives, start with negotiation. Contact the other side, try to work out the issue through negotiation. If you can't do that, avail yourself of mediation services. The Maui mediation services are available. They're very good. I strongly urge you all to consider that, because if you don't advise your client about that, they're going to be very upset with you with burning through dollars for time and costs, because when you show up to court, the court is going to strongly recommend and refer, if not outright, refer the case for mediation. And there's a very good chance that if the parties keep an open mind, the case is going to settle. And it shouldn't have to take a lawsuit to get you to that point. Well, if that doesn't work, you're committed to filing the suit. How do you achieve proper substance? Well, it's through proper forms. The Supreme Court Supreme Court has pre-approved district court forms, and the court rules, Rule 3F, Rules of the District Court, requires the court to provide everyone forms, and the rule requires everyone to use the forms. If you don't use the court forms, you must submit a short explanatory addendum to the document explaining all of the differences between your form and the court form. Every difference. And the reason is because a judge is going to go through 95 complaints, and if there's any form that doesn't look familiar and he doesn't know exactly what's in there that needs to be in there, you could say face sanctions, because it screws up the process. All right, and that sounds archaic, but bear with me. So use the proper form. You fill in the forms, completing specific allegations to state your claim for relief, and you have the person qualified to attest to the complaint to sign the form, making it a verified complaint. And you'll understand the importance of that later as our judges speak to you about that. Then you need to serve the form. Service of process is required under rules of the District Court, Rule 5 and Rules 28 requires that service must be accomplished within 6 months of filing the complaint. If you don't do that, dismissal will result with 5 days notice. So, District Court Rules of Civil Procedure 4 is the applicable service rule. It will tell you who to serve, who can serve, how to serve. Basically, you serve a certified copy of the complaint and summons. A sheriff may serve, the police may serve, a person appointed by the court, a person not a party who is 18 years old, and we recommend an independent process server. This is from the Department of Public Safety list. That list is available in the service center. There's some background to that. If you're interested, the applicable statute is HRS 353C-10. Basically what you're getting is, although any person can go on the list, at least you know that that person is not currently serving a criminal sentence, does not have a criminal record for the past 10 years, is not a registered sex offender, is not subject to any other legal restrictions such as in himself or herself being subject to a TRO, preventing contact with certain persons. And that person needs to have a general excise tax license. So, good for business, all right? Personal service is preferred. If you can't do personal service, you can do substitute alternative service by mail. And if you can't do that, then you can do constructive service by publication. That's the hierarchy. If you're going to be serving by any of those procedures on an out-of-state party, You need to get a court order before proceeding with the service. If you don't do that, you're going to ruin your case, and what's going to happen is you're going to be into the case, you may even get judgment, and you may face having that judgment thrown out because you did not have good service of process. The rules authorizes any person aggrieved by an improper service to challenge that and get proper relief. We have a special rule for summary possession cases, and that is, again, following the hierarchy of service attempts, you serve the person first within the district, you serve the person within the circuit, within the state, and if you cannot serve the defendant within the state, then you can obtain a special court order by applying for it by affidavit. It would direct the serving officer to leave a certified copy of the complaint and summons with an agent or employee, and post that certified complaint and summons on the property, and mail a copy of the certified complaint by registered or certified mail, return receipt requested, distributed delivery. In small claims court, you serve by either personal service through any of those persons that I mentioned, such as the certified, the qualified, or the person on this process server list, or you can serve by registered certified mail, return receipt, restricted delivery. I'm going to restrict my comments to post-judgment practice to letting the other judges address that point. And I have now going to summarize my points by giving you the 5 things you need to know about district court practice and the 5 things you should not be doing, things you need to avoid in district court. So first of all, things you need to know. Number 1, use the forms provided by the court. Failure to use the forms may result in imposition of sanctions. Number 2, serve your complaint and summons within 6 months of the filing of the complaint, otherwise the case will be dismissed. Upon notice, you'll have to go through the problem or the application of applying to set aside the dismissal and reinstating the case. Number 3, ensure that a proper return of service or proof of service is filed promptly. The prompt filing is required by District Court Rule 4G, and if you fail to do that, what's going to happen is the case is not going to be calendared. Courtroom 3C, civil assumptive answer calendar landlord-tenant cases in 3C are put on calendar based upon the return of service. So if you don't have a prompt return of service, you're going to show up without any case being on calendar, probably without a defendant, and even though there was proper service, you'll have to do it again by reserving the certifying complaint and summons and getting a new return of service date. And all the time and effort and money that you put into effecting service in the first time around is going to be down the drain. Don't expect to be paid for that. Number 4, proceed diligently with prosecution of your claim. Your case is going to be dismissed if there's no activity that has occurred within 8 months during the life of the suit. So after you file the complaint, don't sit on your hands. Actively prosecute your claim, because if you don't do that, the computer is going to flag it. A list is going to be prepared of all the cases with inactivity, and they'll be dismissed. Again, you're going to have to be applying to the court with an affidavit explaining good cause why you sat on your hands and why the case shouldn't be dismissed and why the case should be reinstated. Don't do that. Don't do that. Number 5, proceed promptly with submission of your default judgment. The case may be dismissed if the plaintiff fails to obtain entry of a default or fails to apply for entry of default judgment within 6 months after all of the defendants are in default. So oftentimes people come, you have 1 or 2 defendants, both of them default, and then the plaintiff does nothing more, sits on the hands. 6 months goes by. All you needed to do was to submit your proposed judgment, and you don't do that for whatever reason, because your client is saying, I feel sorry, I'm trying to work it out, or I don't know if I'm going to collect money, they promised to pay me money, or whatever it is. Take your judgment. Otherwise, it's all for naught. Here's the 5 things you need to avoid. Number one, do not come to court without checking ho'ohiki. All right, so on our court website, home base, ho'ohiki will tell you electronically everything that's in your civil file. It will tell you what you are unaware of that may have been filed by the defendant or by the court, and will tell you what you filed has not made it into the file and has not therefore made it to the judge. So you need to know what's there. I don't want you to be showing up expecting the judge to know what you just filed, because chances are good you won't have that. And Karen will be talking about Civil Jim's rollout, which is our electronic filing and document management system. Number two, don't waste your time. The plaintiff isn't required to appear for the civil answer calendar, right? And you don't need to be present to ask for entry of default if the defendant fails to appear. The court will do this as a matter of standard procedure. So check ho'ohiki for the default status and the date of the next hearing if one has been set, if no default is entered. Submit your judgment without having to file a motion for entry of default judgment if you have a verified complaint and it is for a sum certain. All you need to do is to submit your proposed judgment, and a clerk will take it. Doesn't have to wait to go to a judge to review. The clerk will take it and enter the judgment for you if it is a verified complaint. If you just try and do things as you go at the outset, you take a phone call, maybe you take a small retainer, and the client says, file the action. When you file the action, the attorney signs off on it, and you get all the way to the end, and then something has happened because your client isn't around, your client is on vacation, your client is out of state. Whatever the reason is, you may not be able to get that affidavit or declaration in for the court to proceed to give you the judgment after default. Don't do that. Number three, don't file pleadings late. It's a tough thing to do because district court time rules are short. We're not like circuit court, where you have weeks and months. The judge will not have had an opportunity to review the document or pleading, will need to review the document or pleading, at least to know what it is, in order to properly exercise discretion to make a decision on what to do. So the pleading may be stricken, or worse, you may be sanctioned. Don't do that. Number four, don't expect the same judge to be presiding on your case throughout. So you may have judge number one for the answer, you may have judge number two for your status, you may have judge number three for the trial, and you may have judge number four to review your submission of the judgment at the end of the case. We only have 3 district court judges. We have 6 per diem judges. And so there's a very good chance you're not going to get the same judge every single time. And when you get different judges, you're going to get different results. You need to understand that the work does not stop just because one of us judges is not in. The per diem judge will attend to all work of the court that the per diem is sitting in for the day. So if you expect to, for example, have your motion to extend time to serve your complaint that is routinely signed off by Judge A, you may get a rude awakening to have Judge B say, well, what discretion or what good efforts, diligent efforts did you make to serve? Denied. And you're done. Don't do that, right? And if you're in trial and on the record and you're in front of a different judge, please don't say to that presiding judge, well, Judge so-and-so doesn't do it that way. Or Judge so-and-so decided that issue differently. Don't do that. Number 5, on the record time is precious. Don't waste it. Right? So get to the point. Be concise. Don't be in there just taking up time, flapping your lips. Take the lead of the judge. The judge is going to know that he has limited time too. So on a motions calendar, he's going to say, counsel, I read your motion. I'm inclined to grant it. Do you have anything to add? Listen to what he said. Don't start into your pre-canned presentation to reread your arguments. right? It's just gonna get things tight and upset. Don't do that. Time is precious. All right? On the other hand, if the judge says, counsel, you're the move on, I'd like to hear your argument. It's a signal that says, look I just got assigned this calendar yesterday. I haven't reviewed any of the 90 files on calendar. So if you want me to decide, give me your argument. Listen to what the judge is telling you, take his lead, and if you're not sure, ask questions. Judge, I'm interested in hearing if you have any concerns about any of the 3 points that you need to agree on in order to give us judgment or the relief I'm asking for. And if the judge doesn't know, he'll say, I don't know what you're talking about. Once you give me your points. Or the judge may say, thank you for that. I'm concerned about number 2 or point number 3, which is, I think defendant may be prejudiced if you're asking me to set aside this default. Whatever the point is, so you can ask questions, communicate with the judge, and just get right to the point as soon as you can, as succinctly as you can, as accurately as you can. And if you can do that, the judges will appreciate that. Thank you.